Pearson.
Thank you, Speaker. Sponsor, I'm deeply concerned about this legislation. As you read it, the student's parent, guardian, or legal custodian has to send information about whether the student has been adjudicated delinquent for any offense listed in subsection B, and it lists a whole lot of these offenses here. I don't clearly understand how or why we think increasing these penalties or this laundry list that you write here is going to help the children who are in need or help the children who have committed these acts or allegedly have committed them. I'm not sure if convictions are necessary. And so why are we increasing the penalty on parents instead of doing all that's in our power to actually invest and support as we should, the children who are in these difficult situations?
Representative Martin.
Thank you for your question. Well, what we're doing here is we're increasing the penalty from 50 to 500 for those that don't disclose. It's already the law that parents are supposed to disclose if their child has been adjudicated to the school. It's very important that our administrators, our teachers, and that our children in our schools are safe. And so one of the good things about this is that when a principal is aware that a child has been convicted or been adjudicated somewhere, they're able to put together a plan for that new student who's been enrolled so that they can get the very services and help that you're discussing. What this does is this makes it where it's indiscriminatory in the sense that every student who is newly enrolled in a Tennessee public school, their parent or legal guardian will be asked that question so that the school system knows that and they can make sure that the child gets the services that they need, and the school knows if they've had a child enrolled who's committed some serious crimes here. We're not talking about two kids getting in a fight, you know, over a girlfriend or something like that. You're talking about some serious crimes here, and I think it's really important that our teachers and principals, that they have the ability, the knowledge of what's going on, and they have the ability to address that. And with that, Mr. Speaker, I would renew my motion.
Representative Pearson.
Thank you, Speaker. And sponsor, I appreciate your answer here. There's a quick question. It is for individuals who have been adjudicated or convicted.
Representative Martin.
Yes.
Representative Pearson.
Thank you. Because again, and this is some other legislation that deals with, you know, determining guilt or innocence before a trial has happened, before a court or a jury has decided someone's guilt or innocence. And again, it is one, prompting a parent to answer a question about their children who are under the age of 18's history and background, which I have problems with. And when it comes to parental choice, why is a parent being forced to do this in the first place instead of protecting their child's dignity, protecting their child in all the ways that we would want for parents to do? And you don't even offer an option for a parent to opt into doing this instead of indeed making schools safer by doing other legislative things that I argue about and fight about a whole lot. We're now increasing the penalty for parents for not notifying from a Class C misdemeanor Class B misdemeanor. And what also troubles me is that according to your legislation, it says, upon request of the school principal or the principal's designee, the school principal or the principal's designee shall ask in writing, which may be provided in a printed or digital form, a student's parent, guardian, or legal custodian, whether the student has been adjudicated delinquent for any offense listed in subsection B. So they can just go to a parent who has not checked that box in writing and just ask, I think your child looks like somebody who has been adjudicated for a crime. And if they refuse to comply with that and say that's biased, that's racist, I refuse to comply, you are now making it a misdemeanor. Unfortunately, I believe that this will have unintended consequences. that this will enhance racial profiling, that this does not make schools safer because it takes away the parents' right to protect their children who may have done something terrible or have not even been convicted of anything that they have been accused of. This is not parental choice. This is not making schools safer. This is not protecting our communities. And so I ask that all of my colleagues, please do not move this bill forward. Thank you, Mr. Speaker.
Representative Martin.
Thank you for your comments. This has nothing to do with race. Absolutely nothing. And it's insulting to think that someone would inject that. Every student that's enrolled in our public school will be asked this question. It is already the law that parents are to disclose this information because it's important that our schools are safe and that our administrators know who's in the building. And if someone has committed a rape or a carjack or a murder, I want my kid in that public school, I want their administrator to know who's in that school for the safety of my wife who's a public school teacher, for the safety of the children. And to bring race into this and say that we're only going to pick and choose certain ones is a fallacy. And I would ask you to continue to enhance the laws that we already have on the books.